found was that if the gag is unconstitutional, there's actually a cause of action that a reporter, like the media has. New York Times, back, I don't know if you're old enough to remember that. Remember the Joel Steinberg case? You ever read about the Joel Steinberg case? It was a terrible case that happened back, I think, in the 80s. You were
Definitely wouldn't have remembered it because I was born in
right.
88. So
right. Okay. So shortly before you were born, I think, was this Joel Steinberg case, which was a terrible brutality case that happened, I think, here in Brooklyn. And the judge had put a gag on the case. The New York Times said that this is an unconstitutional gag. He was gagging the lawyers, I think, in that particular circumstance. And the New York Times says this is unconstitutional. You have to let us be able to interview us because now it's affecting your restriction on his freedom of speech is affecting our freedom of press. So that case was New York Times versus Rothwax. And the court recognized that the Times and the media have a valid basis when someone is being wrongfully suppressed from speaking, that it affects their rights of freedom of press. So based on that theory, I went to the first department and I said that the gag order that was placed on Trump was unconstitutional. And accordingly, that was inhibiting my ability as a member of the media. I happened to be a member of the New York media. So that was affecting my rights of freedom of press. And the issue I had, a lot of people when they hear this, especially people from the left, they assume that, oh, he's some crazy Trumpist. He just wants to help Trump. This had nothing to do with Trump. This is so little and so tangentially related to Trump. It was much more that I feel what happened was that there was politicization that was motivated because of the name Trump, to say we're going to start changing Supreme Court precedent and looking at it in a completely new way. And now, because he's so vile, so evil, so dangerous, whatever it is, that we need to shut him up. And we're going to throw out the Constitution in order to shut him up. And we're going to ignore Supreme Court precedent. Because if you...
Can I ask real quick on that other case that you mentioned? You said over the Steinberg case, it was New York Times v.
Rothwax.
Did that, was that adjudicated in the federal Supreme Court? Or did
that was in state.
That was, okay, so and the highest court in New York is the New York State Court of Appeals?
Correct.
Yeah, okay, gotcha.
Right.
Okay, gotcha.
So under New York law, that I have a right as a member of the media to go bring this action on his behalf. And what I felt was I was frustrated with Trump's own claims. You have to realize that for Trump, his perspective was, this is all a political show. They're just coming after me for politics. They want to try to paint me as a criminal. They want me to say all these different convictions. And you see that the left ultimately, when he ended up being found guilty, they kept saying convict, convict, convict. And he was correctly identifying that. So he leaned in from the perspective of this is political persecution, and they're silencing me because they're trying to cut me out of the politics, and it's an unfair suppression. It's a violation of my freedom of speech because I'm a political candidate. And my point was, I don't give a damn if he's a political candidate. He's an American, and we don't have a right to do that to an American, to silence an American, because if you look at Supreme Court precedent, there's what's considered a heavy presumption of unconstitutionality of any gag order. And if we start chipping away at that, in that case, they're going to, anytime someone is accused of a crime, they're going to say, he's a threat. We have to silence him. If they brought up some ridiculous tax charge on you, whatever charge on you or on me, my channel is considerably smaller than yours, or someone even smaller than me, they can say that because he's speaking, he's riling people up against the district attorney's office, and accordingly, he's a threat, and we have to strip away his silence, his freedom of speech, simply because of the fact that he was accused of a crime, and we're afraid that if he takes to social media, he's going to go out there, he's going to start saying certain things, that we're going to get all these harassing phone calls, and we're going to get, we're going to tell people calling in here. That's not the balancing test that the Supreme Court set up for when you're allowed to inhibit someone's free speech. And I don't want to get too heady with the lawyer talk, but the reliance that they said in Supreme Court cases where they allowed to have a gag in the past, you go back to the 70s and the 80s, there's Shepard v. Maxwell, there's Nebraska Press Association versus Stewart, and they set up a balancing test, and they said sometimes the media is so badly hurting someone else's right to a fair trial and basically trampling all over their ability to have constitutional right of a fair trial. Sometimes in those circumstances, you need to dial back freedom of speech. And then you have to make sure that it's as limited as possible. And invariably they would say, this is not a good enough case. This is not a good enough case. And you have to verify that for certain it's this It's this exhibition of First Amendment rights that's stealing and trampling the constitutional rights. And then you have to say that the remedy is as limited as possible. There's no other possible remedy which would help protect this person's constitutional right to a fair trial. That's the balancing test they talked about. Are you understanding me? So, because I know I get very lawyerly, and I don't want to. I don't mean to be. You're a very smart guy. I know that, but I want to make sure I'm being clear here so far. So they talk about balancing test, and every time they talk about this balancing test of constitutional rights, where it's your First Amendment rights are trampling this guy's Sixth Amendment rights or 14th Amendment rights, his right to a fair trial. So you have this competing balance there, and they said, well, okay, if you're really crushing him, you want to hear a crazy case?
Yeah. For a quick tangent, go for it. I got a lot of questions about this one, but if you want to do another one.
Yeah, it's on this. It's
okay,
on this. The Shepard v. Maxwell case, okay, is back in the 60s before I was born.
Mm-hmm.
This guy was accused of murder, okay? And I think murdering his own family. Everyone in the media thought he did it. Everyone, all the papers going out there saying they do it. Picture in the 60s, a courthouse, everyone smoking in the lobbies, wearing their hats, and the media with their press badge and the flash cameras. And they come to this trial, and the media is everywhere. I mean, everywhere, in the jury well. During deliberations, they're hanging out with the jurors, and they're like, you're going to find him guilty, obviously. I mean, this guy totally did it. So he ends up being convicted. And he says, I never had a fair trial here because the media was, just destroying me. And what the Supreme Court said in Shepard v. Maxwell is sometimes when the media and their expression of their First Amendment right of free press is being manifested so egregiously, so aggressively that it's destroying this guy's chance of having a fair trial, the court has to intercede and stop them from doing that. Otherwise, there's no fair trial. So that's when we'll say we're going to open the door. In general, if you're going to gag someone, we consider that a violation. We consider that something that has a heavy presumption of being unconstitutional. But look, you have to have a balancing test here between these constitutional rights. So, and then there was another case, Nebraska Press Association versus Stewart. There was a handful of cases the Supreme Court handled, which every time they talked about this balance between this balancing test. What the court did in D.C. with the Chucking case, and the same thing they did here with Merchan, is they looked at a completely different balancing test. They say the state has a right to a fair trial. Or sometimes they phrase it as the court has a right, which those are two different entities that they seem to glom together a little bit. And because the court is not getting a fair trial, that is now we get to see about suppressing his free speech. The Supreme Court has never allowed that. They've never endorsed that. They've never taken that position. That's in complete conflict with what the Sixth Circuit says. The Ninth Circuit doesn't agree that the court has a right to a fair trial. They don't agree with that at all. And they say, look, the defendant, what are we worrying about? We're worrying about defendant. It's free speech versus defendant's rights. Here, all the rights were on the same side. You had Trump's right to free speech and his right to a fair trial. They're both on one side of it. And then you have this court interest in fair administration of justice and having fair trials. The Supreme Court never endorsed actually creating a balancing test there. And I don't think we ever should, because I think that our freedom of speech is the most precious thing that we have. And I don't want to see that eroded. I don't want to see that you get arrested and that anyone gets arrested. I don't care if they're left, the right, Donald Trump. It can be, Mussolini. I don't care who it is. I don't want them being suppressed out of some fear that now the state is not going to have a fair trial. The Sixth Circuit, the way they worded it was this. They said, your right to a fair trial is a constitutional right that serves only the people, and the government must be the people's servant, not their master. And if they can't handle a tilt in the balance because a particular defendant has too much power, they basically can eat it. It's hard luck on them. The burden is on the state, and I don't want to see this change. We see in Texas there's a whistleblower who they're looking to gag. That's in the middle of going through the whole process of being gagged. This guy has 20,000 followers, and he only has 20,000 followers because he became a whistleblower. He's relatively in social media landscape. He's a nobody, and the state has said, "Oh, he's too much of a threat.
Sure.
We have to silence him." Do you think that that's a healthy perspective for our court to take? That hey, if someone's going to tweet out things that the government doesn't like, that means that we need to silence them.
Absolutely, yes.
Absolutely,
yeah.
Why would you say that?
So I think the first thing we have to consider is there are definitely times where even our fundamental rights could be taken from us. We can say, whether we're talking about the state coming after them, right? When you try to figure out what form of review you should engage in, right? Rational basis, intermediate scrutiny, strict scrutiny. There are times where even under strict scrutiny, a fundamental right could be implicated that the state will survive a Supreme Court analysis from, where they can deprive us of a given right. There are times when even political